I'm Travis Bushaw, your 2025 Iowa Realtors State President, and I'm here with Justin Hayes, our Iowa Realtors General Counsel. We're going to go over some of our topics that you hear from our legal hotline. So we are here, Legal Hotline Hot Topics.
Goodness.
Are you ready, Justin, for number one?
I suppose so.
Perfect. We're going to talk earnest money, especially as we've seen across the state, across actually the United States, more and more of our transactions are failing at a pretty high rate. Les and I had talked previously, we saw a point this spring where they were failing, 1 in 3 was falling apart. Iowa was closer to like a 1 in 5. So better here, but we're still seeing a significant number that aren't coming to the closing table.
Absolutely.
And so then we have to get through the process of dispersing earnest money, which can sometimes be a little bit confusing, especially if we have a transaction where maybe one client is wanting to cancel and the other client is maybe not wanting to cancel.
Absolutely.
What does that process look like? How do we decide who gets the money? It's can be pretty intricate, and obviously, depending on the amount of earnest money deposit, it can be a pretty significant amount of money. So talk us through that just a little bit, Justin.
Yeah, certainly. So there are a couple of different considerations when figuring out how to disperse earnest money, right? So the first one is going to be, why are we dispersing the earnest money? Is it pursuant to a contingency failing, or is it just that the parties want to walk away from the transaction and it's not related to a contingency? So if it's due to a contingency, then you would just rely on the language of the purchase agreement and what the purchase agreement says about how the earnest money should be handled based on that contingency. So the example would be in the case of a home inspection. You could have some stock language in the purchase agreement that says, if the parties cannot agree on the home inspection terms or what to do after the home inspection, then the purchase agreement is declared null and void and the buyers receive a refund of their earnest money. So those are the simple cases, right?
Right. Yep.
But then there are other cases where the parties just decide that they no longer want to do business with each other. And in those situations, we have to rely on what the admin rules say.
Got it.
So with the admin rules, there are a couple of different options there. The first one's going to be, if you're holding that earnest money, you're required to hold on to it until you receive a release from the parties or until you receive an order, either from a court or from binding arbitration or mediation, some form of binding alternative dispute resolution that guides you as to what to do with that earnest money. Okay. So that's the first subset of options that you have, right?
Got it. Okay.
Now, there may be other times where one of the parties doesn't want to go to court, so they're not willing to bring suit on the earnest money, or they don't want to go to that arbitration, and you also can't get a release from the parties.
Right, and that's the one we tend to run into the most, where we even maybe have a contingency that's legitimate, and buyer's agent submits that cancellation, and buyer has signed it, buyer's agent has signed it. Sometimes even the listing agent has said, yeah, this is valid, but you have a seller that says, absolutely, I will not sign this cancellation and return of earnest money. And so now we're stuck because we technically don't have that cancellation that you talked about that needs to be provided. But we have 3 of 4 parties that know that this is canceled. And sometimes we even have 4 of 4 parties, but still have a seller that for either argument's sake says, no, I'm not going to sign this, or is doing it to hold on to that just a little bit longer, sometimes unfortunately out of spite. So what happens then if we need to move this process along, but we're not at the point where we want to get the courts involved because we know that could be a longer process?
So unfortunately, one of the options is actually going to be to get the courts involved. So there is what's called an interpleader action, which is basically where the party that's holding the earnest money, typically your listing agent, your listing broker, can actually petition the court to have the court determine what to do with the earnest money. Now, granted, it's going to take time.
Is that that's a long process?
It can be, Okay. And, ultimately, that's just based on judicial backlog. Like, the courts are busy.
Right? Absolutely.
But there are also procedures in the administrative code that allow for the release of that earnest money upon certain notice and upon a certain timeline. So for sellers, it's usually like 6 months. 6 months after the dispute has arisen, then you can give 30 days written notice, and then you can release that earnest money to the sellers. For buyers, it's actually closer to 30 days after the dispute, and then 30 days written notice, and then you can disperse that earnest money. Now, I would refer you back to the actual admin rules. It's going to be Chapter 13.1, Section 8. That's going to walk you through the procedures for that. And I guess I would say in those situations, you have to be very, very careful. You have to be careful with a lot of stuff in real estate, like generally,
for sure.
But especially when you're dispersing funds from a trust account, those get audited all the time. So be very careful.
So for brokers that are in one of these situations and they're trying to figure out, we've got 2 parties that are contesting this. Buyer wants their money back. maybe because they need that money so that they can then go make an offer on another property.
Absolutely.
Or you've got a seller that is just holding on to it. Buyer knows they will hopefully get it back, feels they deserve to get it back, but seller is holding on to it. Is the best option then for a broker to talk to an attorney at that point to figure out, or do we send our clients to an attorney? Since we're holding the earnest money, I feel like with our trust, we've got a little bit of liability risk to manage in that capacity.
Yeah, you've got to get in the game because, again, it is a trust account. It will be audited, so you have to be very careful with your disbursements. But I typically tell people when they ask, when there's a dispute between the parties related to the earnest money, the parties should be the ones that are talking to an attorney.
Got it.
Yep.
Perfect.
Because if they need to bring suit or go to arbitration or whatever the case may be, they would need.
And the interpleader that you mentioned there is a client working with an attorney. That's not the brokerage getting that, or could it be?
The interpleader one is actually for the brokerage.
That's the brokerage.
So
Got
that's
it.
the brokerage taking the proactive step.
Okay, perfect. Excellent. Thank you. And we know this is one that we're seeing more of just as buyers are using inspections, which they have every right to do, to void transactions, and then sellers are maybe contesting of, like, wait a minute, is this a legitimate reason to cancel? So the more we see that, or even subject to sale, we've seen that those two in combination with financing has been a roadblock to successful transactions. And so we're seeing more than we've seen previously, but we're also in a market because of additional inventory where people don't have to sometimes just ignore the inspection results. They're willing to maybe say, hey, this isn't the one for me because of this. So we're seeing more and more cancellations because of inventory availability, which is what we saw pre-pandemic. So, all right, so you ready for topic 2?
Let's talk about topic 2.
Let's talk some buyer agreements, because we've obviously, we've been post-settlement for over a year. We saw our code go into effect July 1. We saw settlement and rule changes go into effect in August. And what we thought was going to be a huge learning curve has actually been, I've been very impressed with how quickly our brokers, our realtors, staff persons, and to be honest, even some of the public has figured out, like, this is just how it is now. But there are still plenty of questions in buyer agency, especially when it comes to the agreement itself, the timeline. Does one have to be signed, not have to be signed? And I know there's lots of conversations, and we're still getting guidance from NAR, from attorneys. We're still having discussions at the state level. But one of the big questions, and I know you've gotten this is one of our legal hotline hot topics. So yes, it's part of our Iowa code that a buyer agreement be signed. But we also know that's not just for realtors. That's not part of the settlement. That's part of something that applies to all licensees.
Absolutely.
In what capacity, like, does one have to be signed or not have to be signed in order to do, I guess, some real estate activities as opposed to others? So kind of walk us through that, and I'll ask some additional questions as we go.
Sure. So I guess what I would fall back on for that would be the language 543B.56A, which just walks you through the exact requirements when a brokerage agreement has to be signed, right? So it's prior to listing a property for sale, prior to showing a buyer a property, or prior to drafting an offer on behalf of the buyer. So those are going to be the situations where you have to have that buyer agreement signed. And of course, there's like caveats to these things as well.
Yep, absolutely.
So like, I can show a buyer a property that I have not listed so long as I sign a buyer agreement with them. Like, that's a prerequisite.
Yep. So if it's not your listing, you want to show it, you have to sign one.
Absolutely.
Yep. And it doesn't have to be exclusive. It can be any type of buyer agreement, but one has to be signed there.
Absolutely.
Perfect.
And
but if it's one you do have listed,
that's right.
Talk to us about that, because that's interesting.
Yep. In that case, I don't have to have that buyer agreement signed, but I do have to be careful about exactly what I talk about, right? I can open the door for those buyers, but then if they start asking anything beyond factual questions about the property, I gotta be quiet, and we have to have this conversation about signing that buyer agreement or figuring out how the buyers want to proceed, whether that's with me or unrepresented or having an attorney jump in as well.
Yeah. And we've had lots of conversations amongst our obviously you as general counsel, but our instructors that teach law update, some other attorneys, is how do we start to narrow down, because it's a question that we always get asked. In that scenario you gave where a list agent is showing an unrepresented buyer the property, like, when do I cross over that line of specific assistance? What can I do and what can I not do? And it's a tough line to draw. And that's the conversation we've had with brokers, is like, this is why some brokers, we're not a fan of this, because, what did we say? What did they say? Because that's the other piece of this. They might be giving you confidential information without fully understanding what self-representation is. And,
Yes.
and that kind of leads us into our last part. And I think that's a very important thing, is that, self-representation, unrepresented buyers, still allowed in the state of Iowa if that's the route they so choose.
100%.
They don't have to use a realtor. They don't have to use a real estate licensee. But, the conversation has also been, is part of the settlement, if the courts believe that a buyer agreement and buyer representation is the best for the public, we obviously as an association are going to advocate for every single buyer to use a realtor, because that's in their best interest and they're then protected.
Yes.
But if someone so chooses, they can be self-represented. They can find access to the property either through the listing broker, and they still have the right to do that.
Yes.
Through open houses.
Yes.
And they can either represent themselves, they can have an attorney represent them. But in the meantime, anyone that's not in the brokerage of that listing, if it's dual agency, has the opportunity to show them without having anything written in place, aside from maybe a disclosure of self-representation, so that buyer understands, like, I am not your agent.
Right. So I guess I would just whittle it down and just make it very clear that, again, if it's your listing, if you want to open the door, then absolutely feel free. And that doesn't require you to engage into a representation relationship.
Right.
Yep. But if it's not your listing, then you do have to have that buyer agreement signed.
Absolutely.
And you have to be very careful about the information that you're receiving, regardless, from that unrepresented person, who, whether they become a represented person because you signed that buyer agreement with them, you can be less careful at that point, right? That's your client now. But prior to signing that agreement, if you're eliciting or accepting information, like pursuant to drafting a purchase agreement or confidential information, cross that agency.
Absolutely.
And then what happens, right?
Yep.
So
good. And we've continued to have Greta, yourself, some of our leadership, having conversations with the Real Estate Commission, looking through 193E, saying how do we best protect the buyer as a client and as a customer, so that they fully understand and we fully understand what our capacity is to help without providing assistance. It's a tough area to live in.
Yeah, definitely. We're working on it.
We are. Regularly. Perfect. This is a fun one, and this is a unique one to me. I teach around the state. I teach law data, and we, as we have included as Iowa Realtors, fair housing training into law update, we always talk about our protected classes, and we discuss what that means and kind of what from 1968 to 74 to 1988. And the one that always gets questioned by someone in the class is one of our members that's attending, is familial status, because we know that's a protection for minors and dependent adults. But what does that look like when we do have communities that are 55 plus?
Yes.
And so that's always been a question. I was like, how can they do that?
Yeah.
And then the next question is what if you have one of these 55 plus communities that question you as a real estate licensee and says, Travis, like, how do we know this person is over 55? And you are looking at them saying, great question. I wonder that too. So age is not protected as a protected class, but we know minors and dependents are. So walk us through this, because it's very unique, and it's also Older American Month. Let's
Older
chat.
Americans Month. Yeah. So couple of things here. So with these 55 plus communities, like, the reason they're allowed to exist is based on what's called the Housing for Older Persons Act. So that's administered by the Department of Housing and Urban Development, and it exempts certain housing facilities or senior housing communities from the requirements of the Fair Housing Act.
Got it.
Now, what has to happen for one of these to be legal, I guess I would just say, is the community has to have at least 80% of the 80% of the residences occupied by a person that's 55 or older.
Okay.
At least one member of each one of those households has to be 55 or older.
Yep.
So the big thing here, and you kind of asked the question about like, how do we know?
Yeah, how do
that-
we verify that? Because stuff like this does fall on us once in a while.
So there's actually a Q&A about the Housing for Older Persons Act that I was actually reading through. And one of the things that they allow is to ask for copies of identification.
Right.
But with all these fair housing issues, consistency is the key, right? So they can't just pick and choose, hey, I want to ask like these folks, but I don't want to ask these folks. They should be asking everybody for copies of their identification to prove at least one member of that household is going to be 55 or older.
Which, I mean, we talk about in every fair housing class that we teach with the law update, like systematizing everything that you do. If you're gonna, I mean, even as an agent, if you're gonna ask for an ID before you do showings from one potential client, you better be doing it across the board. If you're forewarning one phone number, you better be forewarning all of them. So, so I'm assuming it's the same kind of capacity here, is just to ensure there's no discrimination against individuals.
Exactly, pretty much that. I mean, and there's also an alternative option where if you choose not to ask for IDs, you can actually have folks fill out like a self-proving affidavit that says I am 55 plus,
right?
And the community can accept that.
Got it.
A couple of different ways to approach it.
Yeah, unique one. And then when this came across that we were going to talk about it today, it was timely because I had just been in a law update class last week where we discussed age not being protected, but the act for older persons. But it was very interesting just in the capacity of that this was a question someone had asked of how do we navigate this where you maybe have someone that's looking at this or someone that is 54 going to be 55. At what point, can we put in a PA and do we delay closing? Interesting aspects of that. So
Absolutely.
Good. I look forward to our next one. I always geek out on this stuff like you do. So we'll be back sometime soon with another legal hotline hot topics.
I love it.
Perfect.
Good to see you, Terrence.
Thanks, Justin.